Alrighty, folks, looks like we are live. This is George with Solo Suit. I'm one of the founders. We help people resolve debt lawsuits, especially help collectors and consumers connect to get cases settled and get good resolutions for everybody. So we are on with my friend Greg. He's going to be talking with us about how to settle medical debts. So Greg, could you go ahead and tell us a little bit about yourself?
Yeah, I'm Greg Anjewierden. I'm an attorney. I practice in Salt Lake City, Utah. And in addition to my legal practice, I also have a company called Debtbrief, where we help people and provide resources for people that are being sued by debt collectors.
Fantastic. And how did you get into this space? Give us a little bit of a background on how you got to where you are.
Early in my career, I did a lot of collections on the plaintiff's side for medical providers. So when people didn't pay their medical bills, I was doing the legal work to collect them. And at some point, I just decided, what I would rather be doing is helping people on the back end of this collection stuff, defending the collections rather than being the one that's going after the collecting.
Right. Okay, great. Why'd you choose to do that? How has it been different?
I don't know. It felt like what I was called to do, I guess, was
Nice.
that. And I didn't like the collecting part of it as much as I do helping people out. Doing the collection stuff, at least from the lawyer's perspective, it's not very engaging or exciting. Don't get to flex a lot of creative muscles, so to speak, but
Right.
I feel like I can do a lot more of that defending, and I like helping the people that feel like they're in the situation that they can't get out of. I like helping them get out of that.
Okay, fantastic. Well, we're glad to have you on the show today. So you are a lawyer. You are
Yep.
licensed in Utah?
Yep.
Okay, great. And then you had a background where you were doing collections for a period of time, and then you switched over to the consumer side. Now you help people get out of debt.
Yep, that's correct.
Is that primarily by settlement, or do you help them proceed in court? How do you do that?
So I provide resources for people to do both. Primarily what I do, it can be expensive to hire a lawyer, right? And a lot of times hiring a lawyer doesn't make sense because you'll pay more to the lawyer than you'll pay in just paying the debt off, or more than you can just settle, or you just can't afford it. You're in this situation where you can't afford it, so how can you afford a lawyer? So I do low-cost consultations where I teach people the steps of how to defend themselves, so then they can then take that knowledge that they didn't have before and either defend the case if that's what they think is appropriate, or settle it if that's what they think is appropriate as well.
Okay. Fantastic. That sounds great. Okay, folks, and just a quick disclaimer, right? So we are not your attorneys. I'm not a lawyer. Greg is a lawyer. We aren't providing legal advice on the webinar. We're just doing a webinar, and we aren't creating an attorney-client relationship or anything like that. We're just doing a webinar here. Alrighty? That's just a quick disclaimer I provide just because of regulations in the space. So getting into medical debt a little bit. Did you do collections on medical debt when you were doing collections?
Oh yeah. And I did primarily first party collecting. So like a dental office, for example, has somebody that wasn't paying their bills. I'm filing the lawsuits on behalf of the dental company or the clinic or whatever.
Right.
So I wasn't working for the junk debt buyers like LVNV or Midland or anything like that, but directly for the providers who were doing their own collection efforts.
Right. Okay. What was your experience like collecting on the medical debts?
I don't love to do it. You're coming after these people that are in tough situations, right? I think for the most part, people would pay their medical bills if they were capable of doing it, right? So you end up in a lot of these situations where you're suing somebody that's just like, I don't have the money, I want to get out. We would settle a lot of them, honestly. And if people engaged us and were honest about their situation. I mean, in a lot of these, almost all of them, we just settle them, right? And
Right.
but I think it took people engaging back with us in the process, and it took them being honest about their situation, for that to happen. But as long as they did that, you know, most of my clients were pretty reasonable in responding to that.
Right. Nice. Okay. Okay. That's good to know. And folks, we have a lot of people on the webinar tonight. If we kind of have some questions for Greg that we're going to go through, but if you have any questions that you want to ask, we reserve most of the time here at the end for any Q&A, any questions that you have. So go ahead and put those questions into the chat on YouTube. Go ahead and put those questions into the chat. If you have any questions you want to ask, just go ahead and put those in, and we'll try to get to those as well. How is settling medical debt different from settling other types of debt?
I think the process when you're a defendant, so when you're the person being sued, I don't consider it all that different, to be honest. I mean, the big difference, I guess, if you're being sued directly by the medical provider who provided you with the medical care, those ones are going to be a little bit tougher to make a good defense on. You're probably more likely to have to settle on those. If you get like a junk debt buyer that has purchased old medical debt, they've got to prove not only that you owe the debt, but that they own the right to collect on that debt. And they've got to have the purchase agreement, that they've properly purchased it. So I guess the difference for me would be if you're being sued directly by your medical provider, if that's the case, probably that you've got to think more about settling sooner rather than one where a junk debt buyer is suing you for medical debt. I think the other thing that can be different with medical debt cases is let's compare it to like a payday loan or a credit card. They've got to prove that you had a contract with them, right? With the medical care, it's a little bit different. They've got to prove that they provided the medical care to you. So that's the contract, is that they're going to provide medical care, not that they're providing, credit to you that you then have to pay back. So, a lot of times the medical care at issue can become an issue in the case, and your medical care can be, made public in this lawsuit because, because if you're saying, hey, I didn't have a contract with them, they're going to put forth proof that they provided you medical care, and, that can end up, out in the public. And so if you don't want that, that can be an issue as well that you've got to think about and take care of.
Right. Okay. Have you found that the medical hardship weighs in a lot on the medical debt settlement process?
I mean, yeah. So a lot of, to be clear, they don't have to. These creditors don't have to give you any pass because you have medical hardship or you can't work or you can't afford the bills or whatever. But a lot of them, I don't want to say all of them, but a lot of them are going to have their own processes for determining if you have hardship, and they'll be able to give you, a settlement deal or waive the debt entirely if you engage them in that process. Now, a lot of times they're going to have their own things that they're going to demand that you give them. They may want to look at your bank account information. They may want to, have you provide, proof of income, to show that you're not making a lot of money or things like that. Things which you, frankly, as a debtor, do not have to provide them if you don't want to. But a lot of them will be we'll only, settle with you for this lower amount if you prove to us that you don't have the money like you claim. So, that can be an issue. And then you've got to weigh, do I want to give them this information or do I not want to give them the information? If you don't want to give it to them, maybe you don't get the settlement that you were hoping for. There's a lot of cons to giving the information. You start handing over your bank information, your wage information, that's going to make it all that much easier for them to collect if they do get a judgment against you, right? So, you've got to really be careful and, only give over that information if you really think it's going to help you settle the debt.
Yeah, how do you help people balance the benefit of providing real documentation around income or medical expenses versus like disclosing that information to the collector, the financial information to the collector.
Yeah, I think the it's always a balance, and I always describe it to people as like these cases are not like you should do this or you shouldn't do this. It's more like a sliding scale, right? And so like there are going to be some circumstances where someone should hand this information over. If you are really certain that like I really don't have any money and they are going to give me this deal if I show the documentation to them, I'm probably more likely to swing to the side of, okay, show them that information, they're going to let you off the hook. If you do have money, maybe you're not being entirely truthful with them, or you do have some money in there that you want to protect. Maybe I'm going to swing to the side of more let's not provide it. But I think every case is different too, and sometimes maybe you're like, I don't want to give them the information because it's going to put me at risk of being collected on. But so I maybe can't get as good a deal as I wanted, but maybe they'll give you like an intermediate deal for not giving the information. You know what I'm saying? So, you've just always got to kind of be weighing. And I think this is the thing that I'm always trying to teach people who are defending their own debt collection cases is you have to learn there's not like right or wrong answers on everything. You've got to learn how to evaluate these cases and determine what the risks are and the benefits and do something that, where you think the benefits are going to outweigh the risks. What's
the best way to negotiate with a debt collector regarding a medical debt?
Well, the first thing that I'm going to do is I'm going to call if they're suing me, if they've already filed the lawsuit, I want to make sure that I get my answer filed first, right? Because when I'm negotiating these medical debts, you want to put yourself where you have the most leverage possible. So using a tool like SoloSuit to file your answer first is typically what I recommend to people before they engage in settlement. I get that answer filed so they know they're not going to get a default judgment against you. And then I'm gonna call the lawyer, and I'm going to talk to them and say, look, I can't afford this medical debt or whatever situation I'm in. I'm interested in settlement. Here's what I'm willing to offer you. And they're going to counter, and you're going to negotiate from there. I think you want to be careful not to ever admit that you owe the debt. You want to assume they're always recording your conversation. And I think this creates a lot of anxiety for people, right? Like, oh, I've got to call the lawyer, and like, what if I say something wrong? So I really love SoloSuit's tool called SoloSettle, right? Where they don't actually have to contact the lawyer directly themselves. They don't have to worry about talking to them. So like, I think SoloSettle is like a great tool for people that maybe have like more anxiety or are afraid they're going to say something wrong. So they don't have to worry about that. They can just make those offers and receive the demands and counter from there.
Right. Yeah, for sure. Appreciate that. Yeah, with SoloSettle, we certainly try to insulate the consumer from the places where they can make mistakes. Right? Like interfacing with a collector, it might be it's really the scariest call for a lot of people. One of the scariest calls they can make is like calling a collector who's working for one of the largest banks in the world oftentimes, and trying to have that difficult conversation, trying to negotiate with a professional negotiator. It's a very difficult place to be as a consumer. So SoloSettle, we are really we're diffusing the tension between the two parties, really acting as a trusted mediator between the parties, trying to establish trust with the collector, trying to establish trust with the consumer, and bring both sides together to leverage a settlement. Well, great. Let's see. In regards to negotiating, do you advise people to make a phone call, negotiate on email, negotiate by mail, text, social media messages? What's like the best real platform to do it? Besides,
yeah, really, you can use any of those. I don't think any of them are necessarily a problem. what I recommend to people is actually that they make the phone call to the lawyer. So the way these collection law firms typically work, right? If you're going to make money as a collection lawyer, you only get paid when you collect. So you've got to have like a high volume of cases that are always coming in. But if you're going to have a high volume of cases, that's a lot of paperwork, a lot of processing, a lot of phone calls. So and then it's expensive to hire a lot of lawyers to work those cases. So typically they will hire like a team of paralegals that make less money than a lawyer would make. So if you pick up the phone and you call, you're going to get put on the phone with a paralegal, and that paralegal is going to be told what the value of that case they can accept is, and they'll negotiate with you, but they won't go below that number. Now, in my experience, you can often get better deals if you can talk directly to the lawyer that's in charge of the case. The lawyer is going to be able to evaluate the strengths and weaknesses of that case and can recommend to their client, I think we really ought to take lower than what you're expecting here because, the defendant has some good defenses that they've raised with me or whatever. The paralegal's not necessarily going to do that. So I recommend that you pick up the phone and you call and you're persistent about getting the attorney directly on the phone. Another good way, and honestly, this is how I've settled most of my cases on the defense side, is when you have a court hearing, you know that the attorney is going to be at the hearing, and you know that they're going to have at least thought about what the settlement value is of the case. And I settle so many cases at court hearings, whether they're motion hearings or pretrial conferences, status hearings. If it's a small claims court, I'll settle it right before the trial starts. If you've got a hearing coming up, don't panic. I know most people panic in that situation. That is an excellent opportunity for you to have face-to-face time with somebody and have a good chance at settling that case.
Yeah, fascinating. Fascinating, right. So the attorney is going to be there. You're not going to be negotiating with the paralegal or even less than a paralegal.
Right.
They will have settlement terms in mind. Usually when there's a hearing, that is outside the flow of. So with a lot of these debt collection lawsuits, right? Like the plaintiff's attorney will file a complaint and summons, and then they'll show up for an hour in court, and the defendant won't be there because the defendant for any of the cases won't be there. So there'll just be the judge and the plaintiff's attorney, and they'll go through granting default judgments on 100 cases in an hour. Is that right? That's my understanding is that happens in various states from time to time. Did you have that experience when you're on the collection side?
Yeah, that does happen in other states. In Utah, the judges won't even have the hearing to grant the default judgment. You don't file your answer, and the plaintiff will file the motion for default judgment, and then boom, it comes through. They don't even have to go to court.
They don't even have to show up in court. Right, okay. And then,
yeah.
So if there's a hearing, so what happens there? So the complaint and summons has been filed, the consumer has filed an answer document, and then possibly they've gone through some discovery documents where the plaintiff's attorney will file the request for admissions or interrogatories. The consumer will respond to those, and then there will be a hearing granted, and the hearing is essentially the same thing as a trial. And you're saying you would show up for the consumer could show up for themselves. Plaintiff's attorney will be there. Before the hearing actually commences, the consumer could talk with the plaintiff's attorney, in the hallway, right? Usually there's a bunch of benches, kind of pews, kind of in a church, practically, in the courtroom, and the action's happening in the front of the courtroom, but people who are waiting to have their case are in the back of the courtroom. The plaintiff's attorney and the consumer could connect and then talk in the hallway to basically wrap up a settlement. Is that kind of how that would work?
Yeah, and you say hearings just like a trial. There can be hearings for lots of different reasons. Maybe one party has filed a motion for summary judgment. Sometimes it's just the court wants to hear the status of what's going on, or maybe it's to set a trial date or something. But yeah, when you go, typically, at least when I've done them, there's just dozens of people that are there for these hearings, and they're just doing one right after the other. Some of them are sitting in the back of the courtroom. A lot of people are out in the halls getting deals done. and these plaintiffs' lawyers that do collections, everybody there knows who they are because they're there every week doing this, right? So you may not know who they are. Maybe you can go to their website and look them up, see what they look like, and then pick them out of the crowd. But when I've done it, I've gone and just said, like, just started asking around, maybe to clerks or whoever, like, I'm looking for this person, and they'll say, oh, it's that guy back there, it's that lady over there, and then you grab them. We go out into the hall. A lot of courtrooms will have little side rooms that you can go in and talk. And I just say, okay, here's what we're offering, and they'll say, I can't do that, but I can do this, and we just go back and forth, and we get a deal done. And then when we've got the deal done, we go back into the courtroom when the judge calls our case, and we say, thank you, judge, but we don't need this hearing today. We've reached a settlement.
Nice.
And then your case is done.
Then that's a wrap. Do you usually have a stipulated judgment that's entered in those cases, or a settlement agreement entered at all?
Well, yeah, it kind of depends. I mean, I always recommend you avoid a stipulated judgment if you can. Sometimes the creditor will insist upon it as part of the negotiations, but that's all just part of your negotiation, right? Sometimes they won't agree to the deal unless it's a stipulated judgment, which makes it easier for them to collect if you don't make your payment plan. And then you just have to decide, is that something I'm willing to do or not? Usually they'll say, okay, if you don't want stipulated judgment, you've got to pay more, or you've got to pay it all up front or something. And in those cases, I'll do a settlement agreement rather than a stipulated judgment. You don't have to do the settlement agreement right there at the hearing if you settle. You can go in and tell the judge, we've reached a settlement, we need some time to do the settlement agreement, and then the judge will usually set another hearing 2 or 4 weeks out. And if you get the settlement documents and the dismissal documents in, you don't have to go to that hearing. Otherwise, you come back in and the judge wants to know why you haven't finalized the settlement documents.
Right. What if the consumer shows up on their own and they aren't able to identify the plaintiff's attorney, and then they get called, their case gets called? Is it too late for a settlement at that point, or can they go up and say, hey, we're interested in working for a settlement, can you give us a minute?
No. Okay, so a couple of things in that situation. You get called up. I've definitely seen it where they've said, oh, I'm actually wondering if I could talk settlement before the hearing.
Yep.
And if the other side will agree, then the judge will say, great, go outside and talk, and then come back when you're done. I'll call another case in the meantime. So you can absolutely do that. I think the other thing that's important to remember is you can settle a case at any time. So let's say you go in there, you don't ask to negotiate a settlement, you go through the hearing. Let's say it's a motion for summary judgment. You lose the hearing. There's now a judgment against you. You could go out in the hall afterwards and still negotiate a settlement. Now, that's tougher because you've lost some of your leverage, right? Because you've just lost the case, but they've still got to get the money from you. So there's still opportunity for you to settle even after the hearing is over.
Right. And sometimes the judge will even encourage the parties to take a minute to settle at the beginning of a hearing, right?
Some courts will actually, and this happens more often in small claims court when you just like go to a trial. Some courts will have mediators present at the courthouse and say anybody that wants to try and mediate the case right before your trial, you're welcome to do so. We've got mediators in the hall.
Nice.
And a lot of times, court will be like 3 or 4 hours, and they'll just have all these cases scheduled. I've been to court where the judge will say, if you go mediate your case right now, I will move you to the front of the line as soon as you're done with mediation, because they know that a lot of these cases are going to get resolved if they get mediated, and they don't have to deal with it. So that happens too.
After you get one of these hallway settlements, does something need to be entered into does some document need to be filed into the case?
Yeah, so when you do a settlement, you got to think of it as like a two-way promise, right? You're promising to pay the agreed upon amount, but what you need in return is they have to dismiss the case with prejudice. So you can prepare a simple settlement agreement that says, I'm going to pay this amount, and when I do, they're going to dismiss the case with prejudice. And then once you get that settlement agreement signed, you can feel safe making the payment, and then the other side should file a motion to dismiss the case. And then the judge will sign the order dismissing the case. If they don't do that, you can take your signed settlement agreement and file your own motion to dismiss, and the judge should do it because he'll see that, oh, they had a contract here, you paid, so I need to dismiss the case now. Right. But that's what you want, is you want the order of dismissal with prejudice.
Right. Great. In regards to medical debt, so we had we had a child recently ourselves, and the I'm in the space. I'm in the space of debt collections. Pretty familiar with all of the billing and debt collection practices. We had we spoke with the hospital bill manager. Asked her to make sure that all the bills got to us, everything is sent to us, so that we can pay everything. They sent us all the bills, got it all paid. Then, like 4 months later, we got a call from a debt collector saying there's a $40 unpaid medical bill. And then we took appropriate actions to get that resolved. Is there any way to nip that in the bud earlier?
Well, okay, so I have a couple of thoughts on that.
Mm-hmm.
The first is when you get medical care, especially if you go to a hospital, you're not just getting medical care from the hospital, right? So, like in the example of having a baby, you're going to get a bill from the hospital. You might get a bill from like the place that runs their labs. You're probably going to get a separate bill from the obstetrician that delivered the baby. That's typically not employed by the hospital. They usually just contract with the hospital. You're probably going to get a separate bill from the anesthesiologist who did like the epidural or whatever. And so, just understand that these bills, they just all start pouring in. And if it's just the hospital, you can call them and be like, okay, I need you to itemize these, put them all into one bill so I can see that, and that'll help you kind of prevent that situation if the bill's from the hospital. But don't be surprised if you get bills from like 4 or 5 different, and you're like, who is Mountain West States Anesthesia? You're like, I've never heard of this company. Well, it's probably the anesthesiologist that did the epidural, right? So I actually had this happen too. I had knee surgery a couple of years ago, paid what I thought were the bills, and then all of a sudden contacted by a debt collector. Well, and me being what I do, I'm like, no.
Yeah.
And I called the debt collector, and I sent a debt verification letter or debt validation letter, and like, I need you to verify this. And they sent me a copy of the bill, and it was the anesthesiologist's bill. And as it turned out, the anesthesiologist had never sent it.
As it goes, right?
Yeah, and then I had to look at it and go, okay, I'm not going to pay this interest or late fees because I never got this bill. But I know I got anesthesia services, so what I went back to them is like, I'll pay this bill, but you've got to knock off the interest and the late fees, which is where we settled on that.
Right. Which is totally reasonable because they never actually even sent you the bill.
Yes,
right.
but they sent me to collections without sending me the bill.
Yeah, I think that's a very similar situation for us there. It's fast with medical debt. It's fascinating how let's say how much room for improvement there is on the billing side for these accounts receivable for hospitals.
Yeah, and I'll tell you one other tip for people too, especially when they get bills from hospitals. I've never had this, but I've heard from other people that have done this. You get all these bills, and from the hospital, it'll just be like a single charge. Sometimes if you ask them to itemize that and break it down as to what all those charges are, sometimes the amount can go down when they start to, or if you ask them to break it down, they break it down and you realize, oh, they're just charging me for all of this stuff, but they didn't provide me all of those services. They're just including it in their rate. And then you can kind of, break it down in chunks and say, well, I shouldn't have to pay this part. And you can kind of negotiate with them that way too.
Right. Okay. Well, we do have a few questions here from listeners that we want to get to. We have one from William. Would I handle medical debt the same way as credit card debt?
I mean, as far as going through the legal process, yes. Debt collection cases, they get classified as debt collection cases in court, but what they really are contract cases. Did you have a contract to pay these people money? So if you're going through the legal process as far as filing your answer, doing your discovery, going to trial, yes, you're going to handle that the same way. I think the thing you have to remember that's different is, how are they going to prove there was a contract? sometimes that may be you sign the contract in that paperwork that you do when you first get to the office or to the hospital. And sometimes it may just be they've got to put on proof that they've actually provided the medical services. So maybe they're putting in medical records, things like that. I think that's going to be the big difference. But as far as going through the legal process, it's going to be the same.
Okay, great. Then we have a question from B. Hello, my question is credit card debt. I was sued by LVNV. I sent an answer to the summons and denied all the complaints. Can I call the collection agency lawyer to settle? I just want to hopefully not go to court if the plaintiff wants to take me to court. So there you go. Basically, the main question here is, can I call the collection agency lawyer to settle?
Yeah, so I think we talked about this a little bit already, but yes, you filed your answer first, which I always think you should do first. Like use solo settle or solo suit to file the answer first, because that gives you the leverage, at least that they're not going to get a default judgment against you. So you've done that, and then it's unclear to me who they are wanting to call. They say the collection agency lawyer. So usually what happens is these debts will get sent to like a collection agency, and the collection agency will start calling and pestering you, and then the case gets assigned to a lawyer, and then the lawyer files the lawsuit. Once the lawsuit is filed, I recommend not talking to the collection agency at all. The person you want to talk to at that point is the lawyer whose name is on the summons and the complaint, because that's the person that has the authority to dismiss the lawsuit when you make the payment. And in my experience, the lawyers are often more reasonable with settlements than the collection agency themselves. So I would call the lawyer that's on the summons and complaint after you file your answer.
Okay, fantastic. All right, folks, so that takes us to half past the hour, so it's about the wrap on the webinar. Greg, thank you so much for coming on. It looks like you might be a golfer. Those golf items on the wall behind you?
Golf. We went to the Masters a couple years ago.
Nice,
so.
Nice. Well, that's great. Greg, thanks so much for coming on. Where can people find out more about you and what you are offering?
Yeah, so my website is debtbrief.com, DEBTBRIEF.com, and then you can find me at the same place on all the socials. I'm on YouTube, Facebook, Instagram, TikTok. So.
Great, that sounds great. And folks, we put his website into the chat, so you can check that out there. We also put a special link that will support Greg if you use any of our services. So go ahead and click that if you want to respond to your debt lawsuit or make an offer to settle on the case.